Good morning. We're here today with Reece Smith, who I'm sure most members of the Florida Bar are familiar with. My name is Laura Vaughn, and I'm a member of the Florida Bar Standing Committee on Professionalism. Good morning, Mr. Smith.
Good morning. How are you, Laura?
Just fine. Today we'd like to talk a little bit about you and your career and your history and get some of your insights and thoughts on issues of professionalism. So if you could start, I'd like you to give us a brief background, if you can, what you've done and how your career started and what you've been doing throughout your career as a lawyer.
Oh, goodness. It's a long time now. I went to the University College of Law and finished there in 1949. Practiced a short time as a sole practitioner in Plant City, Florida, which was my hometown, and then left to go to England, where I studied at Oxford University for the next 3 years. When I finished at Oxford, I returned to Florida and went to the University College of Law as an assistant instructor, assistant professor, I guess the title is, and taught there for a year. And initially, I thought I wanted to make a career of teaching law, but during my first effort, I decided if I were going to teach, I should have some experience in the practice first. And so I've been seeking to get experience ever since, I suppose. After about a year, I left the university and joined this law firm, which was then called Mabry, Reeves, Carlton, Fields, and Ward. And I came as an associate. If I could recall correctly, I got paid the handsome amount of $300 a month. And I have been here ever since with some side excursions into other activities. Almost from the outset, for reasons that I have never quite understood, I felt that being a lawyer was something special. At least it meant something special to me. I was the first member of my family on my father's side to graduate from college, and when I decided to pursue the law and become a member of a learned profession, it meant something special to me, and I thought that I should not only try to be a good practitioner, but also try to be a good citizen and to contribute something to my profession and to the public. Why I felt that way, I don't know.
What was the public perception of lawyers then?
Much the same as it is now, but I think not quite so focused or so shrill as it is today, partly because there were then fewer lawyers, and I think our sheer numbers have had something to do with attracting public attention and public criticism. And of course, lawyers historically have not been popular, partly because of what we do. We are, after all, involved in an adversarial process for a good deal of the time, and someone must lose and someone must win. And I think that lawyers' commitment to society is often misunderstood. When one thinks about it, it's easy to see why. Because speaking as a profession and not as individuals, we are dedicated on the one hand to assure the collective security of society and uphold government, which provides that protection and security. On the other hand, we're called upon to oppose the very government that we seek to support when it is perceived to be oppressive of individual rights. And so one is really in seeming contradiction with the other. Nevertheless, those are our dual responsibilities. I take great pride in being a lawyer because I think without the law and without an ordered society, nothing else that civilized man wishes to pursue could pursue. We'd simply be involved in anarchy and chaos. Shakespeare's Jack the Butcher is frequently quoted. First thing we'll do is kill all the lawyers. What people don't understand is that that statement is a compliment to lawyers, because Jack the Butcher seek to institute anarchy in his England of the time, and he was saying before we can have anarchy, we must kill all the lawyers, because lawyers support and sustain an orderly society. So, although frequently used to speak of us in a deprecation, it is in fact a statement that I regard and should be regarded as highly complimentary to the legal profession. Anyway, I entered the practice of law here in the early 1950s and worked at it pretty hard, like most young lawyers do, for a protracted period of time. I did rather early become interested in the work of the organized bar. I saw that as one way that I could make a contribution to my profession and to the public. And I used one of my first vacations to attend a meeting of the American Bar Association in Philadelphia. The firm then had no ABA members, and it didn't pay people's way to do those things. So I went on my own money and my own time. And because of my age, I was put with the junior bar in the junior bar hotel. I shall never forget it, because my room was on the second floor of an un-air-conditioned hotel overlooking an alley immediately above the exhaust fan from the kitchen. And it was a terribly hot summer in Philadelphia. And I sometimes wonder whether I became involved in the affairs of the organized bar, at least of the ABA, so that I could get a better hotel room than I got on that first occasion. But in any event, I met friends that I had known one way or another and became interested in the work of the Junior Bar Conference. Early on, I recall participating with others in petitioning congressional committees to provide compensation for lawyers appointed to defend criminal cases in the federal courts. There was much of that going on because it was not organized legal aid, and this was before the days of public defenders. And many young lawyers were being appointed to try criminal cases pro bono. We thought that there should be compensation. I recall going with a delegation to Washington and appearing before the congressman who chaired the committee and who seemed to be the key to the whole thing. It was rather ironic, I suppose, or at least amusing in one way, because the congressman before whom we appeared had just been indicted for something in his state, and one wondered whether he ought to be in jail rather than be in the Congress. But nevertheless, he received us graciously, and ultimately the legislation was enacted, and from that time on, young lawyers got paid something for defending cases in federal court in criminal matters. I ultimately became chairman of what was then called the Junior Bar Conference, now called the Young Lawyers Division. And I traveled about the country with the then president of the American Bar Association, Whitney North Seymour, who was a great idol of mine. And of course he spoke to the senior members of the bar, and I visited with and spoke to the younger lawyers. In those days I had to practice as well as do bar work, and so I frequently flew the red eye to get back home in time to go into court and try a case the next day. A little bit later on, I was appointed as city attorney here in Tampa, not as a full-time position, but as a part-time position. I had, I think, 13 assistant city attorneys who were in law offices around the community, only one full-time who was at City Hall, Henry Williams, who was really the municipal lawyer. I served two mayors, Mayor Nick Nucio and Mayor Dick Greco. And during that period of time, among other things, became involved in racial tensions in the community, which over a period of years would repeat itself. And I was involved in trying to solve problems of that sort on a number of other occasions. In the late 1960s, I was first appointed Assistant Secretary of the ABA and commenced sitting with the House of Delegates of the ABA, in which I've been a member ever since. And after that was elected Secretary and served for a period of 4 years in that capacity and became intimately involved in the work of the American Bar Association. About the time I finished my service as Secretary of the ABA, I, of course, was continuing to practice law, but my organized bar attention was directed back to Florida. I served a term as President of the Florida Bar Foundation in its early and formative stages, and then helped organize and was the first president of Florida Legal Services, which was the first statewide legal service for the poor program in the state of Florida. At that time, there were very few voluntary organizations in the state. Of our 67 counties, I think less than 10 had any kind of organization in it at all. And one of the missions of Florida Legal Services was to seek to stimulate that activity and try to create more of it. By this time, the federally funded legal service program was on the scene, and there was a great deal of tension between the private bar on the one hand and the federal program on the other. The lawyers in the federal program felt that the private bar wasn't interested in working on a pro bono basis for the poor, and moreover wasn't competent to do it. On the other hand, the private bar tended to regard the full-time federally funded staff lawyer as a social reformist, somebody who was more interested in class actions and lobbying to affect social change than in meeting the individual needs of the poor. And there was a great deal of tension in the two activities, the two entities simply were not working together. They were hardly talking. And Florida Legal Services was an attempt to try to do something about that in the state of Florida. The Florida Bar in the early stages opposed federally funded legal services, particularly the older members of the bar. Some of us who were younger, being in our younger and more liberal days, tended to favor it. And among other things, I worked with the project director for what was then known as Florida Rural Legal Services, a fellow named Dan Bradley. And 10 years later, Dan was president of the Legal Services Corporation when I was president of the ABA, and that relationship, I think, served us both well. And during this period of time, although this doesn't really relate to bar activities as such, I was counsel for the Mayor's Conference on Fair Apportionment, and this had to do with legislative reapportionment and an attempt to wrest the control of the Florida legislature from the rural counties of the state and place it in the more populous counties on a one-man, one-vote basis. And we went to the United States Supreme Court 3 times in that before ultimately prevailing. And interestingly, this was also a period in which there was much talk and considerable debate on the subject of free press, fair trial, and whether or not the press should have full and complete access to the judicial process and to the administration of justice, and whether or not intrusions by the press might adversely affect the right to fair trial. I point that out because that was in the early 70s, and here we are in the middle 90s, and we're experienced the phenomenon of the O.J. Simpson trial, among other things, and seeing what the press does to inform America in a matter like that, and what the press may be doing. I say press, I should say media. What it may be doing adversely to affect the administration of justice in this country.
Which side of that issue were you on in the 70s?
I was then on the side of fair trial in the debates in which I was engaged. And of course we debated much of the time with members of the print media. At that time, television was just gaining its strength. I became president of the Florida Bar in the early 1970s. One of the things I recall is that I had far more appointments to make in that position than I later did as president of the American Bar Association. It seems to me I was forever seeking to make appointments in the early stages. And if I recall correctly, I had something over 1,500 to make at that time. Why, I don't recall. One of the things that's interesting and sort of lost in history is that I appointed Ed Cutler, one of my law partners, to chair a special committee to study something called interest on trust accounts. At that time, the province of British Columbia and Canada had such a program. And Mr. Cutler and his committee looked at it to see if it might have application in the United States, and particularly in the state of Florida. And as you know, many years later, after slow evolution and much battle in the legislature over banking laws and a variety of things, and with strong leadership which came from others much later who followed me, through their leadership, the IOLTA program was developed, which has been, I think, so important, particularly to the sport of legal aid in the state of Florida. That was a period of time, too, when Article 5, the new Article 5 of our Constitution, had just been passed, and among other things, it called for the first time, for merit selection of judges. And so we were addressing that issue. We didn't know much about merit selection and merit retention. Among other things, I recall having a conference to train the members of judicial nomination committees. Of course, we have numbers of those now. But at the outset, we didn't quite know what they needed to know and how they should go about it. And this was the first conference to address that issue. We also did a good deal of work with judges of the lower trial courts, because Article 5 called for the merger of municipal courts and county courts. At the time, each city had its own court in enforcing municipal laws, and there was a separate court, the county court, which dealt with minor civil and criminal matters under the state law. And we did some preliminary work looking at how we should go about merging these two courts. It was in that period of time that the first pilot project on specialization in the practice of law was instituted within the Florida Bar. And we began to look at specialization, and as you know, it is now an accepted status within the bar. There was a lot of interest, too, in judicial polls, because with merit selection and merit retention, the public was no longer going to be voting on a number of candidates, but addressing in the first instance whether Judge X should be retained in office. So there was a lot of work done during this particular administrative year of the bar on judicial polls, and particularly on statewide judicial polls, seeking to get some uniformity in how this was done. We had a lot of concerns with the media because of the free press, fair trial issues, and I think the first bar media conferences were started about then. And a rather unique issue. There were a number of Cuban lawyers who had just come to Florida as exiles from Cuba. This was at the time that the Castro government was beginning to have its effect. And these lawyers, of course, wanted an opportunity to pursue their profession in this state. But there were all sorts of rules and regulations which required extended periods of study, degrees from an accredited American law school, a variety of other things. And so within the Florida Bar, we formulated a program which was taken to the Florida Supreme Court for approval, which after a proficiency test in English and a limited period of study in a law school, a Cuban lawyer, a former Cuban lawyer, could become qualified to be a member of the Florida Bar. I remember this law firm employed one as our law librarian during that period of time, and for many years we had the only law library, I guess, in Florida that was cataloged according to the classifications used by the Library of Congress. And not that it helped us very much, but Mr. Pacheco, who was our librarian, knew how to do that and thought it was important to do it. This was also a time when the question of the Equal Rights Amendment was very much before the public, and particularly a concern of women. And Reuben Askew was governor about then, and he was interested in supporting the ERA, and I and others took leadership within the bar to get the Florida Bar to endorse the adoption of the ERA, which did occur. These things may not exactly relate to professionalism, but yet on the other hand I think they do somewhat, because I regard service to the public and service to the profession as part of what professionalism is all about. And somewhere in the mid-70s I served a period of time as chair of the State Human Rights Advocacy Committee, which represented the interests of persons who were on welfare in the state of Florida, vis-a-vis HRS and the welfare system, and also chaired something called the Governor's Commission on Advocacy for the Developmentally Disabled, which the commission was appointed because of certain federal laws that had been enacted in that regard, and advocacy was required. I'd long been interested in education because of my brief teaching experience and my academic background. So in the second half of the 1970s, I received, through a variety of unusual developments, appointment as the interim president of the University of South Florida. And I served about a little over a year out there. One of the nice things about being an interim president is if the faculty and the staff and the academic community like you, then they want you to stay, and they're very nice to you. If they don't like you, they know you're going to leave pretty soon anyway, so they leave you alone. So this made it a very pleasant experience for me. I thought I would undertake to solve all of the knotty problems, the big knotty problems out there. One of the big ones was conflicts between the main campus and the so-called regional campuses, and the privileges that faculty, particularly on the regional campuses, should enjoy, questions of promotion, a variety of grants, a variety of things like that. And I made a study of that and wrote a white paper on the subject, which I think is still being employed at the University of South Florida. At that time, the funding was a big problem, as it seems always to be in higher education. And I registered as a lobbyist and went to Tallahassee on occasion to lobby for the state university system and for the University of South Florida. It was great then, particularly trying to get funding for the medical school, because the University of Florida's medical school was much more expensive and was losing a substantial amount of money. So when I came in to ask for only $14 million for our med school, it was easy pickings. The mass seating facility was a decision of mine. I had a friend who was then the dean of the College of Fine Arts who wanted certain monies that was available only one time to be spent for a College of Fine Arts. Instead, I made the decision to build the dome, which is now out there, because I thought the university needed a rallying point of some sort. About this same period of time, and I get a bit mixed up on dates here, I served a term as president of the American Bar Endowment, which runs the insurance programs for members of the American Bar Association and develops substantial monies from those programs, with which it uses to make grants to law-related activities. And one of the big issues we faced in the American Bar Endowment at that time was how to divide the endowment's monies between the claims made by the American Bar Association and by the American Bar Foundation, the foundation being the research arm of the American legal profession and a child of the ABA. In the first instance, it was thought that by those who were early leaders in the endowment that all of the money should go to support of the foundation, except for a few minor projects. But the ABA, as it grew and got more avaricious, wanted a bigger cut of the funds. And there was a good deal of argument about that, and one of my responsibilities was to work out an accord between the ABA and the American Bar Foundation on the division of the funds. There have been several accords since that time. The problem never seems to get solved. I also served a term as chairman or president, I've forgotten which the title is, of the National Conference of Bar Presidents. And the major issue that I can recall dealing with during that year of service was related to a study which the Federal Trade Commission was mounting with reference to the legal profession. And it seemed that the FTC wanted to regulate the profession at the federal level. And of course we lawyers thought that was a pretty poor idea, and we spent a good deal of time both developing organized opposition to the idea and also testifying and working, testifying in Congress or before governmental agencies, and working with the FTC and seeking to resolve the matter. And it was resolved in part later on because of the changes which were made in the rules of conduct and resulted in advertising and solicitation becoming accepted practices in the practice of law. I guess I sort of closed the 70s by chairing the Joint Executive Legislative Committee on Higher Education, where we made a complete study of higher education in the state of Florida and made a variety of recommendations, a few of which were adopted, and it resulted in some restructuring of the state university system. And in Tampa, I also served as a special counsel for a pilot project where we did, in fact, as the first jurisdiction in the state of Florida, merge the municipal courts of Tampa with the county courts of Hillsborough County. And the model which was developed here in the course of that activity is the model which was followed around the state as these courts were merged. I became president of the American Bar Association in 1980. Every ABA president thinks he or she has to have some sort of special project. One of mine was to try to get the ABA to develop a program of long-range planning so that ultimately presidents would be carrying out association policy rather than the association carrying out president's policy. That did result in some better budgeting processes over a period of time, but it was not much of a success, to be perfectly honest. Otherwise, I was quite interested still in the provision of legal services for the poor. At the time I was president-elect, Hillary Rodham, now Hillary Rodham Clinton, or maybe then too, as far as that goes, was then completing a term of service as chair of the board of the Legal Services Corporation. And she was making speeches saying that with the funding that the corporation had, and it was then at an all-time high, that nevertheless it was able to address only 10% or 15%, I've forgotten which, of the civil legal needs of the poor in this country. And I felt that somehow the private bar ought to be working to meet those needs as well, preferably supplementing that with the work of the Legal Services Corporation. So my program was to establish 5 pilot projects throughout the United States where a local bar association would start a volunteer pro bono program and bring lawyers in to work without compensation for poor persons needing legal services. Hopefully the work in coordination with the Legal Services Corporation programs in the area, but if not, just to do it anyway. And we picked Duluth, Minnesota, Baltimore, Maryland, Austin, Texas, Portland, Oregon, and Honolulu, Hawaii for those programs. And I'm pleased to say that all of them are still going. In fact, just last week, I went to Duluth and made a Law Day speech and met with the people in that program up there in celebration of the 15th, I guess it was the 15th anniversary of the program. It seemed that everything came to a head, chaos-wise at least, during the time I was serving as ABA president. It was necessary to have a dues increase, which is never popular. It was decided, or we had to decide, whether to move the American Bar Center from its location on the University of Chicago campus on the south side of Chicago to a location mid-city, up in the Loop somewhere or on the lake shore. And that took a great deal of time and involved a great deal of controversy before the decision was made to move the Bar Center to its present location. It was the executive director, after 18 years, had also resigned, so we had to find a new executive director for the ABA. And the model rules of professional conduct were just completed and were submitted for public comment for the first time, and they were highly controversial, particularly on with reference to whether lawyers could blow the whistle on clients for fraudulent activity. Chief Justice Berger made some speeches suggesting that lawyers in the federal courts were not as competent as they should be in the practice, and so we had a big national conference on lawyer competency. Things like that took up a great deal of my time internally with the ABA, but in the meanwhile, I was also on the road making speeches to bar associations around the country. In the 2-year period as president and president-elect, I spoke in all 50 of the states. I think Chesterfield Smith and I are the only ABA presidents who I went to the White House on Law Day for the signing of the Law Day Declaration, but President Reagan was not there, and Vice President Bush did it instead. President Reagan wasn't there because the day before I was to testify before a congressional committee, President Reagan had been shot. And I recall opening my remarks and expressing concern about that, and Mr. Brady and the police officers. And of course there was great dismay and tension and excitement all over the country, and particularly in Washington at that time. I don't know whether I'm wandering too much for you or getting way behind what you want me to do, but I do want to say something, because I think it's very important, about legal services for the poor. The Legal Service Corporation gained great strength in the 60s and the 70s, and as I've already indicated, it rather took over the field, and the voluntary programs which existed pretty much died out because the private bar, not to its credit, kind of surrendered the field to the federally funded programs, and as I say, the two weren't working together. We identified maybe just 50 volunteer programs about the time that we started this pilot project. At the annual meeting of the American Bar Association in 1980, as I became president, the general practice section and the bar of the state of Wisconsin introduced resolutions to the House of Delegates saying that the funds of the Legal Services Corporation ought to be spent totally, or at least in a more substantial part, on the private bar, and that rather than funding staff lawyers, more judicare programs should be created, and that the funding should go more, that the bar, the charmed words became substantial involvement. I was opposed to that and spoke in opposition to those resolutions. The more moderate of them, however, carried, and it became my responsibility as president of the ABA to implement the policy of the House. And I worked in the Congress for the development of regulations which ultimately simply said that the Legal Services Corporation should seek to direct its work in a way so that the private bar would be more substantially involved in the delivery of legal services to the poor. At the same time, I was trying to get these pilot projects started, and there was a great deal of opposition to my program from leading project directors of Legal Service Corporation field programs. They feared that if voluntary programs got going, members of Congress would say, we don't need this federal funding because the lawyers or the private bar is going to do it without funding. And I went to the annual meeting of the National Legal Aid and Defender Association in the fall of 1980 with a little speech saying, come, let us try to work together more. But the NLADA happened to be the place where had become the home of the Legal Service Corporation lawyers. The ABA was seen to as not hospitable to their activities, and so they centered their activities in the NLADA. I went with my speech there, but it was a week after President Reagan had been elected President of the United States. And there was much concern as to whether the Reagan administration would do away with the Legal Services Corporation. So I threw aside my prepared speech and sort of winged it and said that the organized bar would rise to seek to save the Legal Services Corporation if necessary. And it became necessary in the spring of the next year, and ABA, taking the leadership, rallied the Lawyers of America and over 400 representing state and local bars around the country. I went to Washington and we exercised our right to petition government on the U.S. Constitution, otherwise known as lobbying, and lobbied the Congress, and were able to save the corporation from elimination. Along with other social programs, it did suffer across-the-board 25% reduction in its funding, all of which emphasized, to me at least, the need for more private bar activity, more pro bono activity. The Legal Service Corporation Board by this time was chaired by a good friend of mine named Bill McAlpin, who succeeded Hillary Rodham. And Bill was sensitive to the pressures of the private bar for more involvement in the program. And they were also concerned about the effects of the Reagan attack. So in the fall of 1980, the Legal Service Corporation Board issued a directive to its field programs telling them to use first 10%, later 12.5% of their basic field grant for private attorney involvement. Meanwhile, I'd gotten the ABA to devote $500,000 a year to create something called the ABA's Private Bar Involvement Project. It is now known as the ABA Center for Pro Bono. And so the attack of the Reagan Corporation on the legal services, of the Reagan administration on the Legal Services Corporation, had an unexpected salutary effect, because when the bar went in and started fighting for the corporation, it tended to bring the two together in a way that they'd never before acted. And they began for the first time to cooperate and to work in some sort of concert. Still not perfect even today, but they started doing far better. And with the ABA's Private Bar Involvement Project and the Legal Services Corporation 12.5% money going to its private attorney involvement program, and with a great deal of work by a number of people over the next 10 years, we were able to increase the number of pro bono programs at the local level in this country from about 50 when we started to some 950 today. And today, over 150,000 private lawyers are involved in providing free legal services for the poor in an organized setting. And today, they are working in reasonable accord with the federally funded programs as well. So by participation in that activity is one of the great satisfactions of my career in the organized bar. Ironically, as I speak, the Legal Services Corporation is again under attack. Part of the contract with America suggests the elimination of the program, and once again we are involved in a contest for its survival. I also started the first minority bar conference at the time I served as president of the ABA, and that activity has grown over a period of years in the ABA, where efforts are made by the Commission on Women and by other entities within the ABA to give further support and encouragement to minority lawyers and to female lawyers. One of the best things about working in the organized bar are the people you meet, the relationships which formed, and I've greatly profited from friends that I've made in that work. The chair of the Bar Council of England at the time I was president of the ABA was a fellow named Peter Taylor. He's now the Lord Chief Justice of England, and it's a great treat for me to be able to go see the Lord Chief Justice on occasion, to have a cup of tea or something when I'm able to be in England. And there are ever so many relationships like that that lawyers develop in the work of the organized bar, which enhances professionalism and doesn't hurt the practice of law as far as that goes. After I finished the ABA, I came back to Tampa and spent the next few years pretty much in civic activities here. I served a term as what was then called the president of the Greater Tampa Chamber of Commerce, and once again during that period of time I was called upon to become involved in racial tensions in the community. I chaired the Committee on 100, Committee of 100, the economic development arm of the Chamber. Did a good deal of work with Salomon Brothers as they moved from New York to their Tampa location. And also chaired a drive to create the Children's Board, which is now in effect. We had to get, had to win a referendum which imposed an additional tax in order to create the Children's Board. And it's not easy to enhance taxation through referenda. But if any cause can do it, it's a cause on behalf of children, and we succeeded by a slight margin. When I left the ABA, I had a good friend from Texas who was chairman, or just become chairman, of the Houston law firm of Fulbright and Jaworski. And he was then representing the ABA on the Council of the International Bar Association. And he said his duties with his firm were such that he was going to have to stop that, and he urged me to seek as my reward for a term of service in the ABA to go on the IBA Council. He said it's a wonderful activity that the ABA pays your expenses first class to go to these meetings in delightful places around the world, and you don't have to do any work. And that sounded wonderful to me. So I was elected to represent the ABA on the Council of the International Bar Association, and attended my first meeting in New Delhi, India, where I had good sense to drink the bottled water and stay off the leafy vegetables, and I was about the only one of the American delegation that wasn't deathly ill before it was over. I became interested in the work of the International Bar Association, and discovered that there had never been an American president of the IBA. And I suppose I couldn't resist the challenge. Ultimately, I sought the position and was elected to it, and served a 2-year term in 1988 to 1990. It's an exciting activity to be able to travel around the world and see the legal systems in other countries and get to know judges and lawyers. My work focused once again on legal aid and looking at the problems of the provision of legal aid, particularly in the third world countries and less industrialized nations, where the challenges are just absolutely enormous. I was also interested in seeking to strengthen the organized bar and bar associations in third world countries, and did a good deal of work in Eastern Europe and on the African continent and in parts of Asia and the Middle East on that. My annual meeting was, or rather biennial conference, was to be in Kenya. And so I went to Nairobi on a number of occasions seeking to set up that meeting, and got to know that lovely country and greatly enjoyed my visits there. Less than about 2 months before our conference was to come off, President Moi, the president of Kenya, canceled the conference. He was afraid that the human rights programs which the IBA had would create political dissent, which he didn't want, I flew to Nairobi and ultimately met with President Moy, and we worked out a compromise. There's a lot of interesting detail to this that I won't bore people with now. But in any event, President Moy then reinstated the conference, and in less than a month they had riots throughout Kenya, and a number of people were killed. So I then canceled the conference, and we moved it post-haste to New York City. And I have friends in Kenya who are yet to forgive me for doing that. That's a sort of this was your life kind of thing. I currently teach professional responsibility at Stetson University College of Law and chair a committee of the section of legal education and admissions to the bar on professionalism. People seem to have a great deal of difficulty defining professionalism, and particularly people in the academic world are critical of bar associations and practitioners who call for a renewal of professionalism. And they say, number one, the things you would renew never existed in the first place, and number two, what are you talking about? I think it's easy to be critical in that regard. It's much more difficult to be constructive. It may be that I can't precisely define professionalism, but nevertheless, to coin a phrase, I know it when I see it. To me, professionalism involves a commitment by a lawyer to honesty, to competence, to diligence, to zealous service of the client, but not to the extent that civility is lost or sharp practices are engaged in. It involves civility. It involves an application of high values to the work which we do on a daily basis. It involves service to the profession and service to the public. There's nothing wrong with making a living or a good living out of the practice of law, but in my view, those who are committed to professionalism don't see the making of money as the single goal of the legal profession.
Before you said something about, one of the things you said was a return to something that didn't exist in the first place. Can you tell me what you mean by that, and how maybe the practice has changed over the years that you've been involved in it?
How has the practice changed? I think the greatest change has been the sheer number of lawyers who've entered the field. The greater the number, the greater the diversity, the greater the unusual occurrences, the greater the malpractice, the greater number of sharp practitioners or dishonest individuals one would find. And I think, although it's no greater than in my early days, the sheer enhancement of the numbers has made our shortcomings more visible to more persons, and media attention, and particularly the diversity of the media today has been able to focus upon the shortcomings of the profession and bring them to public attention in a way that it was less effective in the earlier days. There's a loss, again, I think, by the numbers primarily, and maybe by the enhancement of communication and transportation. But there's a loss of civility in the practice of law. When I started practicing in Tampa, we knew most of the lawyers in the community, and by and large, most of them, their word was their bond. And if you needed a 10-day extension to file an answer, you just made a call, and then they said, that's fine, and that was it. Over a period of time, we've learned that you can't do that anymore. and court rules tell us we can't do that. But again, it's simply a matter of numbers. There are a lot of lawyers out there we can't know these days because of their numbers. So I think there's a decline in civility as there is an enhancement of numbers. I think the numbers have also created economic pressures, particularly on sole practitioners and lawyers in smaller firms. By and large, however, I think some of the worst non-professional activity that we encounter today comes from the big law firms, the so-called blue stocking firms, where they really have taken on the attributes of the business community which they predominantly serve and become non-civil, aggressive, hinging on the brinks of sharp practice in ways that I think particularly does not become lawyers of the stature of those who work in larger firms. So I decry activity in larger firms to some extent more than I do in any other part of the bar. It needs to be remembered that about 10% of the bar serves corporate America, and the other 90% serves small business and individuals. And that's where the real practice of law is.
So you think that to a great extent the decline in professionalism has been driven somewhat by clients?
I think that's in part. If I want to get technical about it, or get into greater detail, I should say, I think there are other concerns. My friends in the academic community looking at professionalism, right now I'm chair a committee that's charged with suggesting how we might instill or enhance the sense of professionalism in law students while they're in law school. And the answer that comes from the academic side primarily is that simply teaching one PR course in the model rules is not enough, that there should be pervasive education throughout the whole law school experience in values and in standards, behavior, as well as rules. I agree with that, but I think there's some difficulties with the pervasive method. Number one, not everybody on the law school faculty is going to do it. Number two, not everyone is really willing or competent to do it. But I think much more can be done in that regard. But I tend to be critical of the structure of legal education to some extent. It's very difficult for anyone who's practiced law more than 5 years to now get a permanent position on a faculty of law, to get on a tenure track. They want bright young people who've clerked in courts and had a minimal amount of practice, who wish to pursue a scholarly career. I think one result of that is that there are not enough role models in law schools of lawyers who have embraced the highest tenets and traditions of their profession, who believe in the attributes that I tried to describe a while ago, who have lived them successfully in the practice of law, who have achieved and excelled as practitioners. And I think we need more of those in our law schools. In short, we need a kind of a esprit de corps that they seek to develop it, to use an example, in the Marine Corps. You know, you've got a sergeant major out there, or a top sergeant, or a gunny, who is the epitome of what a Marine ought to be. Burr haircut, ramrod straight back, shoes shine so you can hardly look at them, perfect creases in the trousers, straight as a ramrod, chest filled with ribbons, has been there. we need role models too in the law, just as they do in boot camps in the Marine Corps, or just in the Marine Corps, or there are many other analogies one can make as well. I don't think we have enough of them. And I think the way legal education is structured, it precludes that to some extent. Many law schools, for example, think that the use of adjuncts is bad and should be avoided. They use them some, but they largely use them for teaching in an area where nobody's interested or nobody has the desired expertise. And then very few of them, to my knowledge, actually go out and look for the sort of role model to bring on the faculty that I'm talking about. And I'm going to have a little paragraph or two in the report that we will submit that addresses that particular issue. Bar associations are doing a lot of work in the area of professionalism now. They primarily address it from the point of view of civility. I think that's fine, but simply to come up with a statement of standards and to publish it somewhere isn't going to do the job. We practicing lawyers need our role models as well. We practicing lawyers need somebody to guide and cajole us. I wish our judges would do more in that regard. I wish our bar associations would talk more about the commitment to the profession and what professionalism really means as I've tried to describe it. It's not a race for the short-winded. It's going to take a very long time to achieve those things. But we can't get there until we start. I'm not sure I answered your question, but I rambled a lot.
Yeah, you did. What about the young lawyer? We've talked about the young lawyer in law school, but the young lawyer when they reach the law firm, and you said that they need role models. Do you think that lawyers who've been practicing for some time have an obligation to younger lawyers in training in professionalism areas?
I most certainly do, and training in the practice area as well. But yes, I think there need to be those who serve as role models in law firms and who inspire. And if you look at larger firms around the state, you can find in every one of those firms one or more individuals who have been there a long time and who set a standard and who help younger lawyers understand what it means to be a real lawyer, one committed not only to effective practice and effective representation of clients, but one who is likewise committed to service the public and the profession. And I think that law firms should seek to develop that kind of leadership and should stress it. I think law firms should encourage younger lawyers to do public and professional work. Ought to count on the bottom line. And that firms ought to say that a certain number of hours that you do pro bono or in terms of public or professional service counts just as effectively as another 100 hours of billable time. It's heresy to say so, but this society rewards lawyers far more than any other society does. And one can well ask whether, in view of the contributions that we make, whether the professions, and I go beyond the law in this, whether they're all enjoy remuneration that might be greater than their societal contribution. Certainly medical care, as we know, health care is out of sight. Physicians make huge amounts of money. So do lawyers. I couldn't possibly afford my own services for at the hourly rates that my firm charges for my time. And that's too bad. It's too bad in many ways because there's an enormous satisfaction in being able to serve and help individual clients with their problems. It's rewarding to help individuals. One has more difficulty getting that feeling of reward when one has successfully served a bloodless, lifeless, heartless corporation. That's why I think that pro bono work should be stressed within law firms, even those which serve effectively corporate America, because it brings the lawyers, particularly the young lawyers, in touch with what it means to practice law and in touch with what we're really here for. Roscoe Pound sort of summed it up when he pointed that this is a profession committed in the first instance to service, and no less a profession because we make a living out of it as well.
Do you see a difference between professionalism and ethics?
Yes, I think ethics is part of professionalism. Ethics we need some definitions for. If you mean ethics, the model rules of professional conduct, then I regard those as minimal standards which lawyers ought to employ. They're essentially rules of how to practice law. They're part of the law, like tort law might be. Beyond the rules themselves are all sorts of ethical or moral issues that we encounter. The model rules tell us that when our client says he murdered the two little girls and buried them out by the lake, that we can't tell the desperate families where the children lie. Yet there are ethical and moral issues involved in that. Our rules are essentially role ethics. They are rules of ethics that are fashioned to the role that we play in society. But there are much broader ethical and moral values that have equal application in the law. And people overlook the fact that there is a provision in the model rules that says in counseling our clients, we should take into account not only the legal advice we give, but we are free to talk about political, economic, social, and moral values as well in helping the client to make a decision. But professionalism, I think, is broader because it certainly involves the ethical tenets or rules of the profession. But it also, professionalism involves the broad commitment of service we make. It involves living traditions, living tenets of the law that have long been there. We're criticized by saying, well, you can't really identify what they are. And I come back to the point that I can identify them. They're just the obvious things out there. All the things that make a good lawyer, plus commitment of service to the public and decent amount of time devoted to that.
In the international bar, did you ever have any professionalism issues come up in that context?
It came up in seeking to develop standards or rules of conduct for the international practice. Otherwise, I guess I would say no, at least we could identify them in that regard. There are many concerns, for example, in Northern Europe about the accounting profession and alleged inroads by the accounting profession into the practice of law. And that is described by some of my friends in Northern Europe as a professionalism issue. I don't regard it as such. On the other hand, there's much work done in the IBA on human rights. I think that is a professionalism issue because it amounts to service. But there's no move in the IBA to lead the lawyers of the world back to professional tenets as we think we once knew them, for the reason that the systems differ so much and the cultures and the practices differ so much that it's hard to find unity in that regard.
Are there in other places the same concerns about civility in the practice and things that we have here in the United States?
Yes, I don't know that I can identify civility as such as a concern, but they are concerns similar to those we have in states. For example, there's much concern in the United Kingdom over advertising and solicitation. There's much concern there with efforts to streamline the legal profession. The Lord Chancellor is seeking to do that, and for example, to give audience to solicitors in the higher courts, which has been regarded as the barrister's domain. And of course, the barristers don't like that, and the solicitors do. But they come together on a variety of issues, and advertising and solicitation is one of them. And legal aid is a strange thing in the United Kingdom. They essentially have a judicare system in that country. It's resulted in government allocating large sums of money, much more than we spend in this country. And their per capita governmental contributions far greater than that in the United States. But they pay lawyers, private lawyers, to render legal services for the qualified poor according to a fixed fee standard, and it's lower than the normal rates. So there's certain law firms in England which have essentially live on legal aid fees. The result of this is that other lawyers say, heck, there are lawyers out there who are doing this, so I'm not going to do any work for the poor. And so they have no pro bono movement whatsoever in England. In fact, just now, a recent president of the Law Society of England and Wales has been trying to start a pro bono movement, and a young lawyer who until recently was with a large law firm of solicitors in London is working almost full time on trying to get a pro bono section within the Law Society. I think they'll get there, but they're eons behind us in that regard.
We'd like to thank you very much on behalf of the Florida Bar for your input in a lot of very important issues, and I think we've gotten a lot of very good advice on how to conduct ourselves and things that we can do to have a more rewarding career as lawyers. In closing, is there anything that you'd like to say, any advice to lawyers on issues of professionalism, a little tidbit we can take home with us?
No, I love my profession. I thank you for the opportunity of talking too long about it today. Incidentally, I'm on the same committee you're on. I didn't even know this was happening. Shows I need to do a little more work at home, doesn't it? I don't know that I could summarize advice to the profession or the younger lawyers, except be a good, honest lawyer, work hard, follow the rules, love the profession, and remember you're not in it to make money primarily, you're in it to serve.
Thank you very much.